Good day everyone, welcome back to our course, The Law on Sales. This is part 2 installment. Again, this is your host, instructor, moderator, Atty. Lyndon Maceren. We will start our discussion with option contract. But before doing so, I'd like to remind you that sales is part of the Civil Code, which was enacted in 1949 and took effect a year after, so 1950. So it hasn't been changed, still in effect. So we'll proceed. Option contract. It is a contract granting an exclusive right in one person for which he has paid a separate consideration to buy a certain object within an agreed period. So an example of option contract is when, let's say for example, you are going to reserve a condominium unit. You want to buy a condominium unit because the condominium unit is fast selling. You opted to make a reservation of, let's say, 10,000 pesos. So the reservation fee that you paid is the option money, and the reservation itself, it's the option contract. So reservation fee is the consideration, and you want to buy the condo unit. It's a certain object. So if you are going to prove that in court of law that you made a reservation fee, you need to prove it, because the law does not presume that you paid. Okay. The characteristics of an option contract are the following. Letter A, it is not the contract of sale itself. It is separate and distinct from the contract of sale. It is dominate because it has a name. It's principal because it can stand by itself, but it attaches the object of the principal contract, which is the condominium in our example. It is onerous because it requires it requires the delivery of the money, which is the 10,000 pesos in our example. It's burdensome. It's commutative because the act of the other party is equivalent of the act of the other party. Now it's unilateral because there's only one party which is obligated to perform. The other party now, upon receiving the reservation fee, would only reserve the unit or the object of the contract. It will hold the sale. Let's say the reservations is for 30 days, so it will not sell the unit, the condominium unit, to another party for 30 days. That is the obligation of the seller. But of the the buyer, his obligation is to make good of his he no longer is bound to make an obligation. He is no longer obligated because he already paid 10,000 pesos. Now if he does not pursue the sale, what will happen to his 10,000 pesos? It will be forfeited in behalf of the seller. So unilateral in the sense that it is now the seller who is obligated to reserve the unit. Now in the case of San Miguel, Philippines versus Cuanco, according to the Supreme Court, consideration in an option contract may be anything of value. So in this case, it's the shares of stocks. So unlike in sale, where it must be the price certain in money. So if you make a reservation fee, it could be anything in value. It does not have to be money, but a property could be a consideration in an option contract. So another okay. So how is the option contract exercise? Notice of acceptance should be communicated to the offeror without actual payment, as long as there is delivery of payment in the consummation stage. So in our example, the seller is already reserving the condominium unit to the buyer for 30 days. So there is already an offer by the seller that I am reserving this unit to you. Now it's now the buyer who is bound to give notice of acceptance. So within 30 days, if the buyer decides to buy the unit, say he's going to call, or communicate his uh, decision. I am calling because I want to buy now, to confirm, even though there is no actual payment. So it can be done. So therefore, that's why you can see units already marked sold na. But in actuality, there's no payment yet. Delivery of payment is done when the parties will sign the papers. So, in an option contract, it could be with a separate consideration. So if it has a separate consideration, like a reservation fee, then the option contract is valid. And the offerer cannot withdraw the offer until the expiry period. So in our example, the seller of the condominium unit cannot withdraw the offer. Cannot withdraw, meaning the seller cannot offer the condo unit to another buyer within the period of 30 days. So it is subject to recession, damages, but not to specific performance, because this is not an obligation to give yet. So when the buyer, let's say, when the buyer says that I'm going to proceed and pursue the purchase, but then does not make good of his word or his promise, then it can be rescinded. No? But then the seller can file for damages, but not for specific performance. And if what will happen if the option contract is without a separate consideration? Now there's an old rule. This was made by the Supreme Court before, that the offer is still valid, but the option contract is void, meaning the offer to sell, and not subject to rescission or damages. But under the new rule, the option contract, if it without consideration, then the buyer is only bound for the rule of right of first refusal, meaning he is given the right to refuse first. So he's offered first. Let's say another buyer comes, and then what the seller must do is to call the buyer. Sir, there's another seller. There's another buyer, I'm sorry. There's another buyer who's going to buy your unit. So we are now offering to you. If not, then we will offer this same unit to this buyer. So that is the right of first refusal. You are given the right to refuse. So if the buyer still refuses, then the seller can now proceed with the sale to another buyer. So now we will distinguish option contract from right of first refusal. So option contract is a principal contract. It can stand on its own, while right of first refusal is only an accessory. So it cannot stand on its own. Option contract as to consideration, it needs a separate consideration, and right refusal does not need separate consideration. An option contract, as far as subject matter is concerned, the subject matter and the price must be valid. But in right of first refusal, there must be a subject matter, but the price is not important because we're not talking about the price yet, but you're given the right to refuse first. Option contract is not conditional. Right of first refusal is subject to condition, which is the acceptance of the offer by the buyer. And then the option contract is not subject to specific performance, but right of first refusal is subject to specific performance. Again, when is right of first refusal exist? Now, if you are, let's say, you own a property which is right beside the property which is for sale. In the civil code, if your property is located in a situated adjacent or next to the property which is going to be sold, then the owner of the property must consult to you first. You're given the right of first refusal. Okay, that is found in Article 1623 of the Civil Code. No? So you are a property owner. Let's say you are a property owner of this one, this 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 side, and then this property is going to be sold by the owner. No? Or let's say this property is going to be sold by the owner. This portion here. I'm referring to the rectangle shape which has a which has the phrase subject to specific performance here. Refer to the mouse. So the owner of the property here is going to sell his land. So the owners of these two lands, this one number 1 and number 2, if this is another property here, so the owner of these two lands are given the right of first refusal. Okay, but among the two, who is given the first refusal? This one, because this one is smaller. So if the smaller land, if the owner of the smaller land is given the right of first refusal, then the owner of this one will have to consult with him, notify him, hey, that I am, hey, Mr. Owner of conditional portion of land, I'm going to sell my land here, subject to specific performance. Are you willing to buy my land? This is my price. So you're given, the owner of the conditional is portion is given the right of first refusal. Now, if he will refuse, then this owner here, because they are situated next to each other, will be given the next refusal, right of right of second refusal. There's no consideration involved. Okay. So the right of first refusal creates a promise to enter into a contract of sale, and it has no separate consideration. It's not subject to specific performance because there is no contractual relations here, and it is not an obligation to give, meaning it's not a real contract. And then a new doctrine says that it may be subject to specific performance, but it does not. No. So according to the case of Equatorial Realty Development versus Mayfair Theater, the right of first refusal is only subject to specific performance. So this is another rule made by the Supreme Court. Insofar as it attaches to a valid written principal contract, like a lease. No? So right of first refusal becomes one of its considerations of the contract. Oh, another example of right of first refusal, if the property is being leased by another person. So when the owner of that property decides to sell it, so before he sells it to anyone else, he must offer it to the lessee, no? To the present lessee. Okay, that is a right, the right given to the lessee of first refusal. So effect of the new doctrine, it turned the world of solicitation, which is the negotiation phase of a contract of sale, upside down, because while valid option contract is not subject to specific performance, the right of first refusal, which does not even have a separate condition, may be subject to first specific performance. So this is quite a decision made by the Supreme Court. Another aspect of right of first refusal, it recognizes recovery of damage based on abuse of rights doctrine. So if the seller has abused his rights, then he can be subjected to damage. Or if the either no, if the lessee in our example abused his right, then he can be uh, liable for damages. Okay, let's go to perfection of sale. This is actually chapter 6 of the book. So what's the general rule in the perfection of a contract of sale? So I've said contract of sale is a consensual. So it is perfected at the moment there is the meeting of minds upon the thing of the subject of the contract and upon the price. So it is consensual contract. What is the exception? When the sale is subject to a suspensive condition. So suspensive condition meaning it still happens in the future, and the sale suspensive, so the sale is going to be suspended until the fulfillment of the condition. Let's say I'm going to sell to you this property if I win the case, no? Because that person is filing a case in court that he is going to recover that property because that property belongs to him. So recovery of property, but sold by his brother to another person. And this brother has no authority, that he has authority from him. So now, since the sale depends upon the winning of the case or the recovery of the property, so that is now subject to a suspensive condition sale. So that is a different kind of sale. No? Okay, the requisites in the acceptance of the offer. Now, because in the solicitation stage or negotiation, there must be a valid offer from either of the party, either of the parties, either the seller or the buyer. So if the buyer make the offer to the seller that I'm going to buy your property, so and it requires here that the acceptance of the seller must be absolute if they are facing each other. So when the parties are facing each other or they're face to face, then the offer should be accepted absolutely. No, the seller decides to sell. Okay, I will sell it. And when are we going to execute the contract? Okay. Now, if the offer was made via, or the acceptance was made by telegram or correspondence like a letter. So there it was this offer made by the buyer by way of a letter, and also the acceptance of the seller is done uh, by a letter. So let's say, for instance, the offeror is in Manila and this now gives an offer to buy the property from the seller or from the owner, and by way of a letter. So the acceptance of the property owner is also done in telegram. So when it's done, when is it effective? So the acceptance becomes effective when the offeror receives or had knowledge of the acceptance. So meaning at the time of, because our letters in going to Manila takes time, no? Let's say it takes 10 days. Let's say, for instance, the property owner sent a letter to the buyer to Manila now, today, no? And it would take 10 days. So today is November, let's say today is let's say on November 2, no? So it will arrive there November 12th. But before arriving, before it was received by the offeror, the property owner decided to sell it to another person. Let's say on November 5, okay, since the offer, since my acceptance letter was not yet received by the offeror, I'm now going to sell it to another person who is willing to pay a much higher price. Can he do that? Yes, because it's not yet accepted, no? I mean, it's not yet received. The offeror has not yet received the acceptance of the property owner. So uh, it's still being, I mean, it's still in transit. So nagdagan pa, no? So that happens all the time when the buyer is from another place. Number 3, when the sale is subject to a suspensive condition, like in my example, when the subject property is still under litigation. So there was an agreement that this, the owner of the property will sell it to the buyer if the seller will uh, succeed in recovering the property. So the buyer is bound to pay from the moment the condition is fulfilled. Only upon the fulfilled. But if not, then the buyer can decide to forget it. It is now taking so long a time. No? Lugay mo man ang kaso. So we have a note here, qualified acceptance. What is a qualified acceptance? A qualified acceptance is a counter offer which needs to be absolutely accepted to give rise to a perfected contract of sale. So I'll give you an example of qualified acceptance. Very simple. Okay, a car dealer, say for instance, offers to sell his car to you, yeah, for 500,000 pesos. And you said, okay, I will purchase it, but you must replace the mag wheels with a bigger wheels. Okay, more expensive wheels. And you have to change the stereo into touchscreen. Okay, is there acceptance? Okay, because you said I'm going to buy it, but you have to change the wheels, change the stereo. Is there acceptance? Yes, there is acceptance, but acceptance is qualified because you are making now, you want to make changes of the subject matter. So that's not an absolute, there is, you are in return, you are making a counter offer. You know, you're not really making a qualified acceptance, but you're making a counter offer. You're not making an unqualified acceptance, I'm sorry, but you're making a qualified acceptance, which is a counter offer. And once that counter offer is relayed to the seller, and the seller must, okay, I must think about that, because the wheels, they're very expensive. The one you requested is very expensive. 20 inches, uh, 40 40 centimeters, which is very low profile wheels, is very expensive. Okay, so there is no absolute acceptance yet on the seller, on the part of the seller. So what is, according to the rule, the uh, when the offeree makes a qualified acceptance, then his qualified acceptance must be absolutely accepted in order to give rise of the perfected contract of sale. Again, the parties in a contract of sale before perfection is the offeree, is the offeror and offeree. So the offeror is the one who offers to the other party. The offeree, so I'm going to buy your property. Let's say the buyer, he's the offeror. It could be the seller. Yeah, I'm going to sell my property. Do you want to buy? I'm offering it to you for a very cheap price. So it's either the buyer or the seller, no? Or the owner of the property or the buyer of the property. Okay, let's go to business ads. Business ads, are they definite offers? The answer is no, they're not definite offers, but only mere invitations to make an offer, except when it appears to be otherwise. I think there's not an exception, but in the rule, business ads are really mere invitations to make an offer. Likewise, invitations to bid are not definite offers. Like you see bids, bid, invitation to bid, 1,000 meals, catering, like that, were given during the distribution of gifts. So you are going to provide 1,000 meals. Is that a definite offer? No. So bidding, invitation to bid is mere uh, invitation to make proposals. So that's the rule. Well, business ads are invitations to make an offer. And again, invitations to bid are mere invitations to make proposal. Okay, let's go to auction sales. Auction sale is different. It's bid. It's like uh, it's public bidding. If you've seen in the movie, like there's an auction for jewelry. This jewelry, there will be an introduction of the product. This jewelry was made for the Royal Princess of England in 1901. So it's made way back in 1901. And it's pure 24 karat diamonds, like that, and so on and so forth, etc. So starting bid would be $1 million. And there would be so many people raising their boards, no, their numbers. You'll be carrying number. So that is auction sale. So what is the rule on that? So number one, the sale of separate lots by auction are separate contracts of sale. So because in some auctions it would be in lots, no? Like this is one lot. I'm not talking about property. This is one lot. Like one lot is comprises of three cars, one SUV, one sedan car, and one uh, people's car, like small car. So this is one lot. So if that is the case, then sales of separate lots, it's also a separate contract of sale. Okay. And number two, sale is perfected in auction sales. The perfection of sale is when the hammer falls, like when the auctioneer says sold. So that is the perfection of the sale. Number three, when the seller has the right to bid at the auction, provided that such right was reserved and notice was given to the effect. Because the rule in auction sale that the seller himself cannot bid, no? Like for example, I am going to put my property in auction. Do I have the right to bid to my own property? The answer is no. That's the general rule. But when can it be? When can it happen? So the seller has the right to bid according to this rule in an auction sale if such right was reserved. So I must reserve my right, and notice was given to that effect. So everybody in the auction or the public bidding knows, no, that I can bid for my own property. So it should be, uh, they should all be notified. Okay, let's go to earnest money. The earnest money is the money given as part of the purchase price. So it is part of the purchase price because it is the down payment. So in the code or in the civil code, it is termed as earnest money. But nowadays we term earnest money as down payment. Say how much is the down payment is 10%. That's the earnest money. So it's part of the purchase price. So acceptance is the proof that the contract of sale exists. So there's already a contract. Third, nothing in law prevents parties from treating earnest money differently. The old law or the old concept that it's subject to forfeiture when buyer backs out, but not now. Now new, it cannot be forfeited because it's part of the purchase price. It must be restored. So if the buyer backs out, then meaning the seller has the obligation to refund it to the buyer. Okay. But if it is stated in the contract that if the buyer backs out, then it can be subjected to forfeiture. So it can be forfeited. Yes, it can be valid if it is stipulated in the contract. No? And there's a presumption of perfection of contract of sale when earnest money is already made. No? So when the buyer made his down payment, there's already a presumption that the contract of sale has been perfected. Oh, it's still disputable. So meaning it's still disputable. So it's still, you have to prove that you made the down payment. How would you prove it? By a receipt, or it's better to pay by check to have paper trail. Okay, because according to the rule, it is still disputable. So meaning it's subject to evidence. You have to prove. So we will proceed by distinguishing option money from earnest money. And here are the distinctions. Option money is given as a distinct consideration for an option contract. So it's not part of the contract of sale, but earnest money is part of the purchase price of the contract of sale. Second, option contract applies to a sale which is not yet perfected. On the other hand, earnest money is given only when there is already a sale. Okay, very clear. Third, an option contract is not required to buy, meaning the party in the option contract is not required to buy. There's no acceptance yet. But in a contract of in the earnest money, when the money is already given, so the buyer is bound to pay the balance. Okay, there is now the necessity to buy. Okay, Article 1483 of the Civil Code states that subject to the provisions of the Statute of Frauds and of any other applicable statute, a contract of sale may be made in writing and or word of mouth, or partly in writing and partly by word of mouth, meaning oral, or by inferred from the conduct of the parties. So this is an exception to the consensuality of consensual principle of contract or characteristic. So because there is the provision of statute of frauds. Now, what is statute of frauds? This is a rule which was handed down late in England to prevent the occurrence of fraud. Contracts must be made in writing. So in a contract of sale, when it pertains to chattel or personal property, it, it can be in writing in our own contract of in our own statute of frauds. This is found in Article 1403 of the Civil Code. No? If it is a personal property or chattel or chattel, and the price exceeds 500 pesos, then you have to write it. No? Then if the subject matter of the sale is a real property, then you have to write it. It must be in writing. Okay, so there are form of sales, no? Because of that statute, that provision of the law. So first, the form of sale being consensual, so it should be oral, no? Then because of that law, the statute of frauds, then it needs to be in writing or in written and perfected by mere consent as to the price and the subject matter. So, so it could be oral or in writing. Letter B, in particular form is required under the statute of frauds if, when, if it's personal property, it exceeds 500 pesos. If it's real property, automatic in writing. So it's valid and binding between parties, but not binding to third parties. No? So other parties, meaning the other third parties, can still have no knowledge. Okay. Letter C, reason, purposes of convenience only, and not for validity and enforceability. So the writing is to prevent the other party in the contract of sale to commit fraud, no, and not for binding the other third person or the binding third persons. So cause of action is granted to sue and compel other party to execute the document. So in the contract of sale, if it is not uh, if it involves real property, for instance, and the seller did not execute a deed of sale and there was already payment, so the action of the buyer is to sue and compel the other party to execute the document because it's already been delivered. There's partial delivery on the buyer, which is the payment of money. So in this case, the seller Cannot rescind anymore the contract. It's already valid. But what the buyer can do is to sue the seller and then compel him to execute the deed of sale. Okay. Also, another aspect when form is important for validity. When is it important? Meaning, when is it should be in writing? No? The form. When it is a power to sell a piece of land granted to an agent, it should be in writing. So, if you are a real estate broker, like me, for instance, and I'm going to, I am given the authority to sell the property of my client. Okay, can you please sell this one? So if it is not in writing, the authority to sell, then my authority is not, I have no power to sell that land, no, because it's void. So it should be in writing. So if I am successful in selling that land, then I cannot legally claim for commission because I have no evidence to prove it. Because according to the law, it must be in writing. The power to sell a piece of land granted to an agent. Another one that should be in writing, sale of large cattle. Not only in writing, but it must also be registered with the treasurer of the municipality. No, it is both farm cows. Okay. If not, then it is void. Another should be in writing, sale of land by non-Christian, if not approved by governor. So this applies in the Muslim Mindanao, then it is void. No? So when is form important for enforceability? So when is the written form, what is being stated here? When is the written form important? So I've said statute of frauds is found in Article 1403 of the Civil Code. So these are the following agreements which should be uh, made in writing. First, the sale agreement, which by its terms is not to be performed within a year from the making of the document or the signing of the deed. No? So the sale, let's say it's not going to be performed within this year, 2020 or 2021, so, but only in 2022, so it should be in writing. Another, agreement of sale of goods, chattels, or things in action at a price not less than 500 pesos. So it's not less than 500 pesos. The one I used before was more than 500 pesos. So I should be corrected. No, it should not be less than 500 pesos. Okay. Another one, a sale of real property or an interest of a real property. So if you're selling your interest in the real property, you have you have to execute a written form. Okay. But there are exceptions to the statute in sales contracts. First, when there is a note or memorandum in writing and subscribed to by party or his agent. So there's a note or memorandum. So it's still in writing because this contains essential terms of the contract. The note or the memorandum. No? That's why instead of making a contract of sale, it would be a memorandum of agreement. Or, yeah. Then number two, this is another exception when there has been partial performance or execution Say the seller delivers with intent to transfer title, then receives the price. See, this is my example before. Seller already receives the price and delivers the title, but he did not execute a deed of sale. So lacking deed of sale, no? So in this case, it should be the buyer should sue the seller for the execution of the deed of sale. Number three, when there has been a failure to object to presentation of evidence. So this pertains to court proceedings. No? So during the presentation of evidence, the party failed to object. And then when the sales are effected through electronic commerce. So that's another exception. Yeah. By way of email, there was already an email. That email is already uh, considered as a document now, a legal document. Because before it's not. No, it's not acceptable as an evidence. There's a rule now that any uh, any conversation done by email or by electronic, uh, it's now an evidence. Also, when it is when you buy products uh, online, no, when you buy products online, there's no contract. It's just evidenced by uh, there's the evidence there, transaction number. No? So that transaction number is already an evidence of the contract of sale. So that is an exception to the statute of frauds. Now let's go to consummation stage or the performance stage. This is chapter 7 of the book. So this stage is where the parties both comply with the obligation. The part of the buyer delivers the price and the part of the seller delivers the object and executes the required written form, the deed of sale. So nature of the diligence required, the diligence of a good father family unless other requirement is stipulated. So meaning how to preserve the property. So it's going to be preserved by diligence of a good father of the family. Then consequence, if there is loss of the thing due, then the seller will be guilty of breach if the thing is lost through his fault. Okay? Because the seller, before delivering the property to the buyer, there's already an agreement, there was already payment. Now delivery is now what is to be done by the seller, but the thing is lost because of his fault, then he is to be liable for damages. So delivery delivery is also known as tradition. So delivery is required to transfer ownership. If the thing is delivered to the buyer, the ownership is already transferred. No. See, it covers a twin obligation of the seller, which are to transfer the ownership and to deliver a determinate thing. So in the case of PNB versus Ling, the Supreme Court says that delivery of the thing together with the payment of the price marks the consummation of the contract of sale. Another case, Norcas Distributor Incorporated versus CA or Court of Appeals. The court says that the act of delivery must be coupled with the intention of delivering the thing and putting the buyer under the control of the thing. And we have another case in Addison versus Felix. The Supreme Court says that the execution of a public instrument is equivalent to delivery. But to be effective, it is necessary that the vendor have such control over the thing sold that at the moment of sale its material delivery could have been made. So this is not actual delivery, but delivery of the public instrument, which is the written form. No, public instrument is the deed of sale, which is already acknowledged by a notary public. So now we'll discuss the different kinds of delivery. So number one is actual or real delivery. So when the thing is sold, or when the thing sold is placed in the control and possession of the buyer. Another is legal or constructive delivery. This takes several forms and may be in a manner signifying an agreement that the possession is transferred from the buyer to the vendee. So it could be delivery of title, or delivery of execution of public instrument, or deed of sale. So that is a constructive or legal delivery. So there are different forms of constructive delivery, which has the same legal effect as actual or physical delivery. In the case before that, let's discuss the case of 1040 Realty versus Cruz. The Supreme Court says that what gives rise to only to a prima facie presumption of delivery, which is destroyed when actual delivery is not affected because of a legal impediment. Okay. Now the first constructive delivery or legal delivery is Traditio lunga mano. This is the delivery of a thing by mere agreement, when the seller points to the property without need of actually delivering. So when the seller makes his point, oh, that's the property there. That is already tantamount to delivery, and it's called Traditio lunga mano. In English, delivery by long hand, or by mere agreement. That's the English term. Another one is Traditio brevi mano, which is literally shorthand. Mano is hand. No? Example is la mano. You shake hands. So mano is hand. Brevi is short. So delivery by shorthand is before the contract of sale, the would-be buyer was already in possession of the would-be subject matter of sale. Let's say, for instance, the lessee of the property. So the owner of the property decides to sell it to the lessee. Now the lessee is now in possession of the property, so there's no more delivery. So it's called delivery by shorthand, or Traditio brevi mano. Another is symbolic delivery. This pertains to movables like a car. So example would be delivery of the keys of a car. Then we have constitutum possessorium. This happens when at the time of the perfection of the contract of sale, the seller had possession of the subject matter in the concept of owner, and pursuant to the contract, the seller continues to hold physical possession no longer in the concept of owner, but as a lessee, or any other form of possession other than in the concept of owner. So it's quite very long, no? But in short, this is the opposite of Traditio brevi mano. No? Now, let's say I'm the owner of the property and I want to sell the property. So I'm going to sell it to you. And you purchase it, paid me, we execute the price. But after executing the deed of sale, transferring the property to your name, I remained in the property, but not as a concept of owner, but I remained in the property as a lessee. No? Lessee na ko. Therefore, I am now renting the property to you. So that is constitutum possessorium. And lastly, we still have one, uh, quasi-tradition. This is delivery of rights, credits, or incorporeal property made by placing titles of ownership in the hands of the buyer. Also allowing buyer to make use of rights. So quasi-traditio. And the last is tradition by operation of law. So there are instances when the execution of public instrument does not produce the effects of delivery. So what are these cases? Number one, when there is a stipulation to the contrary, the execution does not produce effect of delivery. Meaning, in the contract itself, it's stated that we are executing this deed of sale uh, only to prove that uh, we are executing in the deed of sale, but not to transfer the uh, not yet to transfer the land or the property because he still has to make good of his payments. So let's say it's installment sale. So there are still payments to be made. So, but there is already execution of deed of sale, no? And it says that it's still to be the whole price has to be paid until the such time that the whole price is paid. Then it now produces the effect of delivery. So it's stated in the contract. Another, when at the time of execution of the instrument, the subject matter was not subject to control of the seller. So meaning there's somebody else who is controlling the property. So there's not produced effective delivery. Another, when the subject matter should be within the control of the seller, he should have capacity to deliver it at the time of execution of public instrument when he wants to effect actual delivery. So this pertains to almost the same. So seller is not within the control of the, it's not in control of the subject matter. Fourth, when such capacity should subsist for a reasonable time after the execution of the instrument. So reasonable time depends on circumstances of persons, places, and things. Okay, those are the cases. Now let's go to delivery of fruits and accessions and accessories. So the right to fruits and accession and accessories accrue from time of sale, from the time the sale is perfected, but no real right over it until it is delivered. So meaning the buyer only gets real right over the accession and accessories of the thing upon delivery. No? But rights to the fruits already accrue to him. So meaning if there is already a contract of sale agreed that I'm going to buy to you this, if any there are mango fruits, no? Upon agreement, then the fruits of that mango tree already belong to the buyer. But real right over that mango fruit will only pertain to him once there is delivery. No? Then we have delivery through courier. So general rule, where the seller is authorized or required to send the goods to the buyer, delivery to the courier is delivery to the buyer. So that is the rule. But there are exceptions, no? A contrary intention appears or implied reservation of ownership under paragraphs 1, 2, 3 of the Article 1503. Like the first one, free alongside or fast. This happens when goods delivered alongside the ship is already delivery to the buyer. So the twin effects deemed fulfilled. Okay. Another agreement would be FOB or free on board. And there are different types of free on board. Shipping point or shipment or destination. So free on board shipment or shipping point is when the goods are already delivered at shipping point of shipment. So it means that delivery to carrier by placing goods on vessel is already delivery to the buyer. But if it is free on board destination, then the goods will reach the port even if not disembarked yet from the vessel. Then once the vessel reaches its destination, even not yet disembarked, then there is already delivery to the buyer. Then we have CIF, cost, insurance, freight. There are two. So when the buyer pays for these services of the carrier, there is already delivery to the buyer. You know, when he pays, or and meaning the carrier is the agent of the buyer. But when the buyer pays the seller for the price, from the moment the vessel is at port of destination, there is already delivery to buyer. So meaning the transfer of property ownership happens only when the vessel reaches its port of destination. Okay? There is no transfer of delivery yet. So meaning if it's lost in transit, then it is the seller who will suffer the loss. So now let's discuss completeness of delivery. If the subject matter is a movable or movables, the delivery of thing plus accessories and accessions in the condition in which they were upon the perfection of a contract, including the fruits. So it's already perfected, no? So meaning the thing must be delivered plus the accessories and the accessions, and they should be delivered in the condition when they were at the perfection of the contract. So no changes to the thing, it should remain as is. Let's say we perfected the sale today, and the thing is going to be delivered next week. So you don't change, no? Let's say for example it's a car. You don't change the tires. You don't change the stereo. No, you cannot change the tools. The tools inside should remain. Diba? These are accessories. You should not change the seat covers. The seat covers should remain. Okay. Letter B, when the seller delivers to the buyer a quantity of goods less than what he has contracted to sell, then the buyer has the option to reject or accept it because it's not yet complete. Diba? Let's say it's a buyer orders 1,000 sacks of rice, but the seller delivers only 800 sacks of rice. Then it's not complete. So in this case, the buyer has the option to reject or accept. Seller has nothing, cannot do anything. There are exceptions, except when accepts that with knowledge that the seller is not going to perform the contract, is not going to be performed the contract in full, then he must pay at the price stipulated. So in our example, the seller delivers 800 sacks of rice instead of 1,000. So if the buyer knows that, if he accepts, then the buyer knows that the seller is not going to complete the delivery, meaning the 200 sacks of rice will be discarded. Order of 200 sacks of rice no longer to be delivered by the seller. Then the buyer is now obligated to pay the price in full as stipulated per sack of rice. Letter B, when the buyer accepts and consumes before knowledge that the buyer will not perform the contract in full. So the buyer will be liable only for the fair value of the goods delivered. Okay. Letter C, when the seller delivers to the buyer a quantity of goods now larger than what he has contracted the buyer to contracted with the buyer. So the buyer has now the following option: accept the contract and reject the rest, or accept the whole and pay the price as stipulated, or reject the whole if subject matter is indivisible. So the buyer can reject. So these are the different options that the buyer can. No? So let's say the buyer ordered for 1,000 sacks of rice, but the the seller delivered 2,000 sacks of rice. So these are the options: accept per contract and reject the rest, or accept the whole, pay the price stipulated, then reject the whole if the subject matter is indivisible. So in the case of rice, it's not indivisible, so you cannot reject the whole. No? What is indivisible? Like a car, for instance, it's indivisible. So it's larger, meaning probably it's more expensive. No? He ordered for a cheap car, and then what's delivered is an expensive car. So in that case, the buyer has the right to reject, the option to reject. Letter D, when the seller delivers to the buyer the goods he contracted to sell, then mixed with goods of different description, which are not included in the contract. So in this case, the buyer has two options. First, to accept goods which are in accordance with the contract and reject the rest, or reject the goods entirely if they are indivisible. So let's go to immovables. So delivery, sold per unit or number. Okay. If the sale should be made with statement of its area, rate at certain price, deliver all that may have been stated in the contract. If impossible, the remedies of the buyer are the following. No? Because in some cases the properties are sold in unit. Okay, I will sell to you unit 1 and 2 if it's a condominium, no? Or a house, or a number, lot 1 and 2, lot 3, lot 4. Okay, but there's no area. But here, if the sale should be made with a statement of its area, so there is already an area. So lot 1 is 500 square meters. That's the area, 500 square meters. So the price is certain, and how much per square meter. Okay. But if the delivery, if all that may have been stated in the contract is impossible, then these are the remedies. Meaning, if the area is lesser, instead of delivering a lot with 500 square meters, what is after surveying, because you will not know it unless you will survey the property, no? Upon surveying, it lacks the size, no? So these are the remedy of the buyers to rescind the sale, or still buy the pay the price, but proportional reduction of the price. This happens when the area which is missing or lacking is not less than 1/10 of the area agreed upon. No, so not less. So in our example, it's 500 square meters. So if the lot or the property delivered is only 450 square meters, so 50 square meters is 1/10. No, 500, 1/10 of 500 is 50 square meters. So this is applicable. No? But if the area of the property is only 400 square meters, so missing 100 square meters, so this will apply. So greater area, so the buyer still accepts per stipulation and reject the rest. I don't know, greater in area, so instead of 500 square meters, what is delivered is 600 square meters. So the buyer can reject the rest, no? I only need 500 square meters. So why are you delivering me a property with 600 square meters? Or accept the whole area, then pay the contract price. Okay, not available, it says judicial sales. So pay the whole. If it's, you know, the price per square meters, then you apply. Now, there in some cases there is an agreement that the property will be sold for lump sum. What what does that mean? Sold for lump sum, meaning there is no area talked about. We don't know the area. It's just lump sum. How much I want this, how much the property is sold by the seller, let's say 10 million pesos, everything in it, like the house, the swimming pool, etc., etc., the development included, that's lump sum without any area being mentioned. No? Okay. So when the price unit is not indicated, so this happens when there is no square meter per the price per square meter. How much is this per square meter? The buyer would ask, I don't know. So the seller would say, I don't know. As long as I want my house and lot sold for 10 million pesos. That's it. So that's lump sum. No? Because you don't know what's the area. You don't know, you just know there is a swimming pool. So that's lump sum. So if the area delivered is either greater or lesser, then it will not be adjusted. No? It will not be adjusted accordingly because it's lump sum. The buyer has no remedy in case the area is small because you bought it lump sum. Say so it should be provided in the contract. Contract of sale is sale in lump sum. Okay. So we don't talk about the area. We only talk about the price. Okay. Understand? Okay. Okay, we talk now. We are now go reach the topic of time and place of delivery. When should the time and the place of the delivery of the thing in a contract of sale? So rule number one, it should be according to the stipulation in the contract. According to what is stated in the contract, if it is stated that the time and place of delivery is done, then we follow the contract. If not stated, then we follow the usage in trade, meaning the customs or the practice, what has been practiced in trade. Or rule number three, the seller's place of business or his residence. If number one and two are not found, no. So third rule, delivery of the thing should be at the place or business or residence of the seller. Or the residence of the seller is not within the city of the buyer, then the fourth rule would be where the place or thing is found. So this pertains to movables, no? So let's say the owner is in Manila and his property is here in Cebu. So he wants to sell it, his car in Cebu, because he used to work here in Cebu. So delivery of the thing would be in Cebu. So because it is, let's say these three are absent, so where the where the thing is found, so in Cebu. And the time would be at the reasonable hour of the day. Reasonable hour means within office hours, so 8 to 5. So the effect of delivery is the general rule here. The ownership of the thing sold shall be transferred to the buyer upon the actual or constructive delivery of the thing. Exception when the contrary is stipulated. In such cases, when it is a contract to sell, it does not transfer delivery. When there's a sale or acceptance or approval, so it is still subject to the acceptance or approval of the buyer, or if it is a sale or return contract. So meaning the buyer has still the option to return, and the number of days is stated in the contract. So who bears expenses of delivery? It's the seller. No? The seller bears expenses for the delivery. So we'll stop here. We'll stop with the delivery of the thing, and we'll continue our discussion in part 3 of my video installments. So if you have any questions, clarifications, or suggestions, you email me at my macerenlodge@gmail.com. Or if you want to make a chat through my MS Teams or FB account. So keep on striving, keep on learning, keep studying, because knowledge is wisdom, or wisdom is power. Thank you and have a good day, everyone. Stay safe.